Good morning and welcome everyone to our webinar on Employment Contract Essentials, how to protect and grow your business. My name is Comfort Nkang and I'm the practice leader for the Employment and Workplace Health and Safety here at LegalVision UK. So before we begin today, a couple of quick housekeeping items. Firstly, you will be receiving the recording and slides of this webinar in your email. Whilst we are going through the webinar content, please feel free to submit your questions in the Q&A box and we will answer them in the end. And please complete the feedback survey after the webinar. We would very much appreciate your time doing this. So you'd love to know that for the next 48 hours, you are eligible for a free consultation with one of the lawyers at LegalVision to discuss how we can help your business. In order to claim this complimentary legal consultation, we would ask that you please provide your contact details in the survey at the end of this webinar. So before we move on to the agenda, I would just love to understand generally what you expect from the employment contracts webinar today. So which aspects of your employment contract do you find most challenging? Is that how to protect business interests and trade secrets, how to differentiate statutory and contractual rights, drafting termination clauses such as PILON, that's payment in lieu of notice, or is it updating contracts as your business grows, avoiding common contract pitfalls, or perhaps all of the above? And also, if you're not sure and you're just here to learn, do feel free to let us know that. We'll give you a few moments just to submit your response, and then I'll move on to setting out the agenda for today. Okay, that's a really, really good response. So generally, it's an equal split, more like, between trying to understand and differentiating the difference between statutory and contractual rights, updating contracts as your business grows, and some of you are not sure and you're just here to learn. So really good, because I'll be touching on the statutory and contractual rights during this webinar. So moving on to the agenda, what we hope to cover today is touching on job descriptions, offer letters and when to use them, and written employment statements. I'll also be discussing the key and wider clauses to include in your employment contract to protect your business, as well as touching on how to attract and retain talent through the contract terms you introduce or you have in your business. We'll also be talking about protecting your business interest and how to deal with remote and hybrid working staff. Finally, we'll then touch on flexibility and changing employment terms, termination clauses, notice periods, as well as common mistakes that you should avoid. I will also leave some time so that you can ask me any questions you have, and I'll answer those. But please, if you don't have time, or if we don't have time to cover your questions today, do take advantage of the free consultation by leaving your contact details with us. So moving on to job description and offer letter. I wanted to touch on this because it is relevant when considering hiring a new staff to usually take some time to prepare a written detailed job description. So job description and person specification will help you before advertising the vacancy. And what it will help you do is just to allow you to focus your mind on the skills and the experience you require for the vacant role. Also, by having a job description set out in writing, it will ensure that you follow an objective approach during your recruitment process, an approach that is not influenced by any discriminatory considerations. Especially as well, if you have your hiring manager carrying out the recruitment process, as a business, you want to know that before they start interviewing candidates, they do know the skills that the business is after for that particular role. And of course, following your recruitment process, usually we hope that you find the right candidates for the role. And if you do, although not mandatory, you may want to go in first by sending an offer letter. An offer letter is just sent after the recruitment process or the interviews you have with a candidate. If you identify the right candidate, it can be a way or a means of setting out key terms that they will later on find in the employment contract. Example, you can use that opportunity to set out and confirm the identity of the employer. You can also use this opportunity to provide key information such as the job title, the salary on offer, and any conditions that you want to place on the offer of employment. And when I talk about conditions to place, generally some offer of employment will be subject to criminal records checks. Some, of course, well, all will be subject to them having the right to work and live in the UK. So you want to specify that in the offer letter so the candidate knows that. And generally, some businesses, yours may be included in this, may require reference from current or previous employers of the candidates. So if you have any such conditions, then it's always good and useful to set it out in an offer letter. You can have the approach of having an offer letter and, of course, attaching an employment contract, or you can allow for the candidate to review the offer letter, accept the offer before you then follow on and send the employment contract. So next, in terms of the obligation you have when it comes to sending an employment contract, an employer must give employees and workers a document, and usually the document will state the main conditions of employment. And we usually call this written statement of employment particulars. Or you can just call it an employment contract or contract of employment, which includes additional terms as well. This must be sent to your employee or worker when they start working for you. So usually before their start date, you want to send the contract, so you give them an opportunity to review the terms, sign and return the signed contract to you before their first day of employment with your company. So what must you include in the principal statement? So these are the key things to include. We've set them out here for you, but generally you must confirm the employer's name. So the full name of your company. Usually that is your name as stated on Companies House, together with the company number and your address as well. You want to also include the employee's full name and their address too. Job title and is always key to include as well, because you want it to be clear as to what the job they're going to be doing is, as well as the start date of employment. You also have to set out, of course, the pay information. So how much will they be paid, ensuring that this at least meets the national minimum wage and national living wage, depending on the age of the candidate. And of course, you also need to set out how often you're going to pay them. Is that weekly? Is it monthly? And exactly when will you be paying them? So that can be on or, around the end of the month if you're paying monthly. It's important as well that you must also provide information on the hours of work and the days you require your employees to work, the place of work, and generally, if there is any probationary period that they're subject to, then that should be set out in the contract. If you're going to be offering any training, especially where the training is mandatory, then you must set that out in the contract of employment. With regards to mandatory training, if the company usually would pay for this, but if you require the employee to contribute towards the cost of such training, that has to be clearly set out in the employment contract. And just be mindful that the cost of any training contributed by an employee doesn't take their salary or pay under the national minimum wage or the national living wage. And generally, you have to also provide information on notice periods, as well as on sick pay and other paid leave they'll be entitled to, such as maternity, paternity, or adoption leave and pay. So Once you have these key terms in your employment contract, there are other wider written statements that you are usually required to include in a contract as well. So you were looking at things like workplace pension schemes. As we know, employers are obliged to set up a workplace pension scheme when they start hiring, so that eligible employees will be automatically enrolled into your workplace pension scheme. Or should you choose to, you can delay the auto enrollment for up to 3 months. I must flag that if your company chooses to delay enrollment onto the pension scheme for up to 3 months, if an employee opts to join before the 3 months is up, then you must let them join. So that is the legal position. But again, if you want to delay, then you have to set it out in writing to them, and usually that should be found in an employment contract. The other things as well you will include in the wider terms of your employment contract is whether any collective agreements, like with the union, applies to the terms and conditions of employment, and different procedures when it comes to your disciplinary and grievance procedures. For example, who the employee should write to if they wanted to submit a grievance, or who they should write to if they wanted to appeal the outcome of a disciplinary action. Okay. So again, if you have any questions on what to include in your employment contract as the term, please feel free to ask your questions using the Q&A box. I'm going to move on to how to enhance contract terms to attract and retain talent. As we all know, it is quite competitive in the job market. There are really great candidates that sometimes smaller businesses or startups, find it difficult to attract these talents. So these are tips that you should consider, or you may wish to consider for your business. The first one is place of work. Of course, post the pandemic, a lot of employees and people prefer a more flexible work approach or workplace. So if you wanted to attract and retain talent, you may consider, instead of having on-site only workplace, you may consider hybrid workplace, whereby they work 3 days from your office if you have one, and 2 days from their UK home address. Or you can have a fully remote workforce, depending on the nature of your business and the roles of each individual. Generally as well, you can think about additional benefits. Of course, there are statutory rights and benefits that are reserved for employees and that are that applies to workers. But you can think about additional benefits you can offer candidates or individuals that want to work for you to attract them to your business. Some of the ones that our clients think about and implement are private medical cover, or you can think about performance-related bonuses. It can be annual bonus, or it can be a per quarter bonus. You can also consider whether you can issue shares to your employees. And of course, if you seek advice, you may seek corporate advice in terms of EMI shares, which is enterprise management incentives, and or other tax effective benefits when it comes to shares that you want to give to your employees. We do have a corporate team here at LegalVision UK that can help you navigate and consider shares as an option when you're looking at benefits to your employees. The other benefit you can think about is, in the UK, for full-time employees, the holiday entitlement is 5.6 weeks per annum. So that is usually 28 days per year, inclusive of the 8 days bank holiday we have in England and Wales. You may want to increase that. So instead of 28 days per year, you may wish to offer 33 days, or even more if you can. There are some businesses, very few, but some businesses have unlimited holiday. Before you can consider that, I would ask that you take advantage of our free consultation and speak to us as to how you can manage that in your workforce, because of course you do not want employees to abuse that. And the other benefits as well is to do with company sick pay. So statutory sick pay is an entitlement that employees and workers can be entitled to statutory sick pay, SSP, after the waiting period, which is currently 3 days. And usually is paid at a rate that is determined by the government. It is currently £118.75 per week. and that can be paid to employees for up to 28 weeks. What some companies would choose to do is to have company sick pay, which may mean if employees are sick for up to 10 days in a year, then the company will give them their usual salary, which is full pay. That is also one way you can attract and retain talent in your business. And of course, we have the family leave, as I mentioned earlier, such as maternity leave, paternity leave, adoption leave. And with all these leaves, if employees are entitled, they will receive statutory pay at the rate determined by the government. But then if you wanted to enhance those leaves, then you can give employees full pay for a certain period, part or all of the leave, and that can always attract candidates and talent to your business. So moving on from there, I would like to discuss how you can protect your business interest within your employment contracts. The first one is to do with confidentiality clause. So employees, of course, will generally owe your business an implied contractual duty of confidentiality during and after they've worked for you. However, it's usually recommended that you also add a confidentiality clause within your employment contract. And by doing so, the key thing is that you'll be able to define what does confidential information mean to your business. So any particular trade secret or any particular confidential information that you would like to highlight can be added to that definition. And then you can ensure that employees can't make or use any copies of your confidential information, and generally steps that they need to take if you request the return or deletion of these information. So that's usually why we recommend having a confidentiality clause. Some people call it an NDA, non-disclosure agreement, useful to have in a contract just to set out the scope of confidentiality within your workplace. The other key thing as well that is worth considering when trying to consider ways to protect your business is looking at company equipment. Some companies may not have the resources or the money to be able to afford equipment for all their employees and workers. And in that instance, they may just ask the employees to use their personal equipment for work. But generally, we recommend that where you can afford to do so, having a company equipment that you provide to your employees so that they can use that to deliver services and to work for your company. The reasons for this is that confidential information will only be stored within this company equipment. And when the employee wants to move on and no longer work for your company, it's easier for you to just ask for them to return all property belonging to the company, including the equipment, such as a laptop or the mobile phone. So the other clause as well that is always important, although not mandatory to include in an employment contract, is intellectual property, IP provisions. Especially if you're recruiting an individual that is a creative or in a research role, and they'll be creating a lot of IP rights and inventions in the course of their employment. What you want to do is to make sure that you have an IP clause that is wide enough to cover the scope of their duties and what they'll be creating within the employment contract. What the clause will do is to deal with assignment of IP and inventions during employment, making it clear to employees that any IP, any invention they create during employment will belong to the company. And what that does is just to reaffirm the legal position that IP created in the course of employment shall automatically belong to the company, especially when it relates to your business and the role the individual is currently carrying out in your business, and especially if they're using your equipment and your resources to create that invention. Within the intellectual property clause as well, you would also include a waiver for employees' moral rights. The other clause as well that is worth considering within an employment contract to protect your business is what we call restrictive covenants, so post-termination obligations. And that includes non-compete and non-solicitation clauses. Just to set the background with this, previously you would find that case laws really control the scope as to what is reasonable when you're setting the restriction periods within a non-compete or non-solicitation clause in a contract. What happened was in 2023, the government confirmed that it would introduce a statutory cap on non-compete clauses, and the cap will be 3 months. The reason for this is that some of these clauses were becoming unreasonable and seeking to prevent an individual from working in an industry after they have left their employer. It is not meant to be a clause to punish individuals or stop them from leaving your company or to leave them unemployed once they leave your business. What you need to think about is just to make sure that you have clauses like non-compete that are reasonable. So generally you're thinking about what is the risk? What risk are you trying to protect? And also what harm can this individual cause to your business if they were able to set up next door, for example? So if the government's proposal comes into force and you have a longer non-compete clauses within your employment contract, I would just like to flag that it may become void or unenforceable, except for the first 3 months, of course. So that's why our recommendation is generally try to ensure that the period in which you prevent employees from competing with your business once they leave employment is reasonable, and reasonable when you consider the role of the individual when they were working for your company. If you have a junior employee with not much access to trade secrets, then you may not need a restriction within the employment contracts at all. So the other thing as well is restrictive covenants includes non-solicitation of clients and employees. Again, that usually will be fine. Typically, companies can have 6 months, 9 months, or 12 months when it comes to non-solicitation clauses, and especially for senior staff as well. Okay, so let's move on to the considerations for remote and hybrid workers within your business. First of all, with regards to health and safety, employers have a duty to take reasonable care of the health and safety of employees and people that work for their organization. So it is important that when providing a safe working environment, this also includes providing a safe working environment for remote and hybrid workers. So generally, that includes conducting an appropriate risk assessment. Example would be the display screen equipment assessment, just to make sure their workstation, even at home, is safe and is not one that will expose them to the risk of back or neck injury. And then the other as well is to consider data protection. So data protection clauses you will always find, usually find in an employment contract as well. And the reason for this is it can refer employees to a privacy notice for staff. Privacy notice for staff is generally a policy that you have to inform your employees and your staff the type of data you're going to collect from them, how you're going to use the data, or perhaps the lawful basis for processing such data. And also the privacy notice will set out the rights of the individuals as well. It's also important to also have a data protection policy, which your employment contract can refer to. And the purpose of this internal policy is just to guide your employees, which generally they would deal with personal data and handle personal data on a day-to-day when working and performing their duties. So that data protection policy helps guide them as to how you wish for them to process such data or to access such data whilst working for you. You must also ensure, of course, that you have adequate safeguards in place to protect personal data from being misused within your organization. Very quickly, looking at flexibility and how you can change the terms of your employment contract. First of all, I would recommend that when drafting your employment contract, you have clauses and you have your clauses that will allow for reasonable changes as your business grows. First of all, is the place of work. When it comes to place of work, you can add that employees may be required to attend the office or co-working spaces for meetings if they're fully remote. The other thing as well you can add to give yourself flexibility is when it comes to hours and days of work. You can draft the clause to make room for reasonable overtime. And you can also specify that the hours and days of work may vary based on business needs, just to manage expectations. You can also add layoffs and short-time working clause within your employment contract. And what that does is that it means that if, unfortunately, you don't have enough business to keep your employees busy, and you need to, ask them to stay at a home or to reduce the hours that they work, then you can rely on this clause within their employment contract to do so. If it's going to be an unpaid layoff, then of course they will, they will receive a statutory guarantee if they're eligible. But then you should note as well, if your employees are laid off for a long period of time, usually if they've been laid off for 4 weeks in a row or 6 weeks in a 13-week period, they may write to you and ask to be made redundant. Again, if you need help with that at all, please feel free to use our complimentary offer today and book a call to have a legal consultation with myself or one of the senior lawyers in our employment team. And in terms of varying the employment contracts again, if you have a substantial change that you want to make to an employment contract, you can do so by express agreement. And what that simply means is you can speak to the employee, and if the employee agrees to the proposed change, then you can make the change. My recommendation is usually to make sure that that is captured in writing. The other as well is unilaterally imposing the change following consultation with the employee. If you wanted to change a term of the employment contract and you've consulted with the employee and they're not quite keen on accepting the changes, then in some instances, you may go ahead and just unilaterally impose the change, but do be mindful because that does carry legal risk. So depending on the circumstances as well, there can be a risk for breach of contract or unfair constructive dismissal. So my recommendation would be to speak to one of our lawyers before you do so. There is also the common one we all know, which is fire and rehire, is been talked about recently a lot. This is where you propose a change, employee or employees are not happy with the proposed changes, and then what you seek to do is to terminate the existing employment and offer the employee employment on new terms. So offer to re-engage them on new terms. Historically, this was quite popular. However, from July last year, employers are required to comply with the government's statutory code of practice if you wanted to go down the route of dismissal and re-engagement of the employee. Mindful of time, just running through the key requirements of the code. The first is just to make sure that you provide information to the employees as early as reasonably possible. You should also ensure that you have details provided to the employees to include what the proposed new terms are and the changes you're trying to make, who will be affected, and you should also flag to the employees the business reasons for you trying to make those changes. Try and give yourself enough time to consult with the employees because a meaningful consultation process is required under the code. And once that is done and you follow the consultation process, then you should re-examine the proposal submitted by the employees and seek to find alternative ways to achieve the objective you sought to achieve. Only after that thorough process would you follow through to go through the fair dismissal procedures within your policy and then give the employee maximum notice as possible. Once you give them notice, you terminate, then re-engage them as soon as that is practicable for you to do so, and document the entire process in writing as well for audit purposes. So generally, the question is usually, what are the consequences of non-compliance? I mean, if you do not comply with the code, it doesn't automatically create a liability, but your failure to comply with the code may be admissible in evidence, which means there may be an uplift of up to 25% in any awards given to the employee. And the recommendations as well that we usually make to our clients includes making sure that when it comes to termination, the clauses are set out correctly in your contract. So clear termination clauses, as I said, making sure the length of notice is also included, but also bear in mind the statutory notice period. Usually it works out to a week for each full year someone has worked for your company, maximum being 12 weeks for people that have worked for your company for 12 years or more. Alternatively, if you're hiring a key or senior staff, you may want to give them a contractual notice that is higher than the statutory notice, maybe a month or 3 months, for example, from day one of employment. You also have to consider clauses like garden leave, and usually garden leave means that employees during notice period are not working, they're at home. If you need them, you call on them to work. But then it helps, it helps give your company the certainty of a more controlled handover, balancing the employer's protection as well as the employee's right. And of course, you will pay them whilst they're on garden leave. And finally, you may want employees to leave immediately and exercise your right to pay them in lieu of notice. If you were to do that, just do know that the payment in lieu of notice must be subject to tax. So the common mistakes you should avoid is having an unsigned employment contract or not having a contract at all. As I mentioned earlier, you must ensure that your employees and workers have their contracts in place before they start working for your company. You should try to avoid ambiguous or inconsistent wording in your employment contract. It's important for the contract terms to be quite clear, so there's no misunderstanding when it comes to enforcing the clauses. The other is just looking at restrictive covenants or post-termination restrictions, making sure that it is going to be enforceable by ensuring the terms are reasonable when you're preparing those contracts. Key thing is as well, if you're paying your employees the national minimum wage or national living wage rate for the year you hire them, please review your contracts yearly, usually before April or around April, because that's when the rates change, just to make sure that you continue to meet those rates and the new ones that are published by the government. And if you have any questions on employment status as to whether someone you're about to bring on board is an employee or a worker, please book a call with us and use the free consultation and we can guide you through that. Okay, so thanks so much for sitting through that, and I hope you really found it very, very useful. So that concludes the main part of our webinar, and you might find our publication useful. So generally, we have a comprehensive publication on how to hire and inspire in the UK. It's a guide that our clients find really, really useful. Please download that and let us know if you have any questions. And you should join our next webinar as well, which is on what SaaS businesses need to know about data privacy and cybersecurity. That webinar will take place on Tuesday, 15th of July at 11 a.m. So we're going to answer your questions very shortly. But just before I do that, and whilst you submit your questions to me, I'll take a minute just to tell you more about LegalVision and how we help our clients through our membership. So by becoming a LegalVision member, your business will have unlimited access to our full legal team of 100+ specialist lawyers. And that is just for all your business as usual needs. It's like having your own in-house counsel for a fraction of the cost, of course. And our team can assist you with everything from unlimited document drafting and reviewing. And that includes reviewing of employment contracts, business contracts as well. We also help with unlimited legal advice consultations. And of course, you're offered one today, which you should take advantage of. And we also help our clients with unlimited domestic trademark registration and a lot more. So as a LegalVision member, you won't have to worry about the cost of lawyers because there'll be certainty in the cost per annum. And just think about it as having your own in-house counsel and someone to go to. We'll take care of all your legal, business as usual legal needs, just so that you can focus on running your own business. And in terms of the employment team, of course, we'll help you with drafting your job description, offer letters, employment contract, and your workplace policies. And that's just a few of things we help with. So to learn more about how membership or our desk extension service can help you, do request a free consultation when the survey appears at the end of the webinar, and we can speak to you about that in more detail. So for now, I will be answering the questions you have for me. So let's do this. Okay. So the first question I have here is the employment contract to address restrictive covenants, or should they be expressly addressed separately? That is a very good question. And I mean, you can do both. Generally, you can have the restrictive covenants set out within an employment contract, or you can have it as an addendum to the employment contract. So you can refer to it as a schedule attached to the employment contract. But usually, I would recommend that it is part of the employment contract, because what you want to do is to ensure that the candidate, before accepting the job offer or before accepting to work for you, have considered all the terms of their contract and terms and conditions that apply to them before making the decisions to accept it or not. I wouldn't recommend sending the contract for the individual to sign and later on seeking to introduce your restrictive covenants, because by trying to do so, the employee may ask for additional consideration. So they may ask for maybe an amount to compensate them for agreeing to these additional restrictions. So for that reason, I would say if you don't want it included within the terms and conditions, which some people feel actually makes the contract too long, I don't like it, then still have the clause within the contract and refer to the restrictive covenant as an attachment, a schedule, or an addendum to the contract, and provide that attachment to them at the same time. Okay. The next question, is it legally permissible to preclude or limit any consideration of working from home? That is a good question, especially with the current workforce post the pandemic. So there is no legal requirement for you to permit employees to work from home. So, however, you may have an employee in your workplace that is, example, injured or disabled, and one of the adjustments that may be recommended by their GP or specialist, or perhaps that may be recommended by occupational health, if you've referred them to occupational health for an assessment, may be that they work from home maybe once a week. And we have seen that, especially sometimes with conditions like stress and depression, individuals may be encouraged to work from home a day or two in a week. So generally, overall, there is no legal obligation that, for you to allow people to work from home, but it may be an adjustment you provide because an individual is disabled. And also, if you wanted to mention in your employment contract that no individuals are allowed to work from home, then you can do that. Nothing is stopping you from doing that as well. Of course, if employees, for one reason or the other, outside of outside of reasonable adjustment, if they just wanted to submit a flexible working request to change their work location, then they would do so, and you can speak to us and we'll guide you through that process. Okay, so there's another question here, and the question is, what do I do if I cannot find the employment contract that was signed by an employee when they started working for me? That is a good question. And to answer that, generally, if you cannot locate a signed employment contract that you sent to an employee to sign and return when they joined your business, we would usually recommend that you ask the employee to resend a copy of the signed contract. It may just be that they forgot to send it to you, or it may be that they actually have a copy that you don't. If you ask the employee for a copy and they don't have it and you can't locate any copy, then we would recommend that you prepare a contract of employment to reflect the implied terms and conditions that the employee has been working under whilst in your organization. So things like salary, their annual entitlement to holiday, all those things shouldn't be reduced as a result of the new contract. So the new contract should seek to clarify the terms of their employment. If, let's say, the employee is not happy with additional terms that they feel they shouldn't be subjected to, example, a restrictive covenant, then you can speak to them and negotiate to see how you can have that implemented, perhaps by offering them a little pay rise or a lump sum amount. They may be happy to sign the employment contract with the new introduced terms. So again, generally, we always recommend having a contract in place as soon as possible if you realize that a current employee does not have an employment contract. Okay, so I have one more question that I think I'll have time for, but please feel free to take advantage of the free consultation and book a call with me if I haven't gone through to answering your question on this call. So the other question is, what if the employee is not agreeing to all the terms and conditions in the employment contract I've sent to them? So again, this is a really, really good question. And in some cases, it's not as easy as you've sent an employment contract to a prospective employee, and they simply sign and return. Especially with senior employees, some of them will instruct a lawyer to review the employment contract on their behalf and flag any risk or any clauses which they would, they wish to change. And then they may propose amendments to the contract. If that is the case, then what I would usually recommend you do is to ask them to put their proposed changes or questions in writing to you, either by email or a different avenue you think is most appropriate. But I would recommend it is in writing. And then you should consider the proposed changes and also what is the business impact? How would it affect your business if you were simply to accept to the changes proposed by the prospective employee? Alternatively, if you feel you cannot accept the proposed changes, you can always suggest a workaround so both parties can agree and the employment contract can be signed. But this is something that we see a lot, especially with senior employees. So don't be so worried if you have a markup employment contract come back to you. If you don't understand the changes an employee or prospective employee is asking about, then please feel free to speak to a lawyer, and then we can, of course, help you understand the terms and the implication of accepting their proposed amendments. So that is all that we have time for today. And sorry if I haven't answered your questions. Please do submit your details in the survey at the end so that we can assist you and I can go through your questions with you if I have not answered it today. And of course, if you want to learn more about our membership and how we can help your business with your legal needs, again, do take advantage of the legal consultation, and then we can speak to you about the scope of our service and how we can support you. While this is a free webinar for all, and I really truly value your feedback, and so does my team. So please complete the 30-second survey at the end, and it will be so great to have your feedback. Thank you so much for joining us today, and do have a good day. Bye-bye.